Welcome everybody on the second day and unfortunately also the last day of this conference. But I suggest we'll make the best of it and we will jump right into it. So I will start with kind of rhetorical question as I will answer it myself. So what do Brazil, Germany and Italy have in common? So indeed, at least all four of them won the Football Cup 4 times, but they also share something else. Together with 8 other countries, they are the only countries in the world having an animal constitutional provision. Yet more and more countries are knocking on this constitutional door, including Belgium. So my focus of this contribution will be on the Belgian legislative constitutional proposals. But before we delve deeper into these proposals, I will first present an introductory frame of reference regarding Belgium's legal approach towards animal welfare. Then the main part falls into 3 parts. First, the existing proposals, then an important digression to the constitutional case law, and then new options will be explored as well. So, but first things first, who am I? For those expecting other fun football facts, I will have to disappoint you because I am definitely not a football expert. However, as a PhD researcher specialized in environmental law, in particular animal law, I will guide you today in providing answers to the options that Belgium should consider when including animals in its constitution, which in fact may not only be helpful for Belgium, but also for other countries who are also on the same route to explore constitutional animal rights. So the introductory frame of reference, it might be helpful to compare it to Germany, as both countries have a federal state structure. So in Germany you have der Bund und die Länder, and in Belgium you have like the federale staat en de gemeenschappen en de gewesten. So whereas in Germany animal welfare is a competence between the federal level and the sub-state level. In Belgium, animal welfare is an exclusive competence of the regions. So you see that before 2002, when Article 20A of the German Basic Law was amended, already 11 of the 16 state constitutions included animals in their state constitution. In Belgium, we do not have such thing as a state constitution. We do have, since 2018, a Walloon Animal Welfare Code, but it does not have any constitutional stated. It should just be perceived as common animal welfare legislation. Then the structure of both countries, their constitution. In Germany, you have first the title Die Grundrechte and a second title Der Bund und die Länder. In Belgium, it's the other way around. So the Title I of Germany corresponds to Title II of the Belgian Constitution. Then you also have like Belgians and their rights. At first sight, at least from a structural, formal perspective, there are similarities. But if you will zoom into both state objectives, it is very different. And why is that? Because the lack or the judicial review or the lack of judicial review. According to Article 142 of the Belgian Constitution, the Belgian Constitutional Court can only review acts with provisions that are lodged under Title II of the Belgian Constitution. And as we will see in the next section, the proposal now is to put an animal welfare state objective in Article 7 bis, which is enshrined in Title I of the Belgian, 1 bis in the Belgian Constitution. So the existing proposals. Maybe first some background information. In 2016, a renowned Belgian animal welfare organization launched a campaign to raise awareness on a constitutional animal welfare provision for Belgium. And this certainly paid off in that soon afterwards, the proposal was submitted in the federal parliament. And what did that proposal look like? Well, the aim was to revise Article 7 bis of the Constitution. But as I already told you, Article 7 bis is lodged under Title 1 bis of the Constitution. And although the aim of the submitters was to provide a legal benchmark for instance, the Constitutional Court, they did not take into account the specific legal consequences of a choice of positioning in the Constitution. And this was exactly what one of the experts in a discussion about the proposal pointed out to. And therefore, one of the commanders concluded that in the current shape, this proposal will not have any effect beyond a purely symbolic one. And to meet this shortcoming, as a response, two other members of the parliament submitted amendments to this original proposal. So to meet the shortcoming of judicial review, they suggested to add animals in Article 23 of the Constitution. And indeed, Article 23 falls inside this judicial scope of the Constitutional Court. So in this respect, this option meets the lack of a judicial review. I already mentioned repeatedly like the Constitutional Court, but what is now the exact approach of the Belgian Constitutional Court regarding animal welfare? So we now will delve deeper into the case law. If we zoom into the Constitutional Court's case law, if we start with the entry into force of the 1986 Animal Welfare Act up to now, we can encounter 17 animal welfare-related judgments. So 3 of them were ruled in a pre-Lisbon period, namely before Article 13 of the TFEU was adopted. With regard to the other 14, we can see something remarkable. Already in the first case that was brought before the Constitutional Court after Article 13 TFEU was adopted, the Constitutional Court made the following argument, which you can read on the slide. And remarkably, it will consistently and repeatedly use this argument in all the following animal welfare-related cases, regardless is it about fur farming, abandoned fur farming, or the tail docking of horses, electric dog collars, and even also the famous ritual slaughter case. It's always the same wording that the Constitutional Court of Belgium uses, so it's kind of settled case law now. And each time that animal welfare legislation was challenged, it was found that it was not violated because this argument of Article 13 TFEU. However, there are 2 exceptions. First is the Walloon Animal Welfare Code, and the second one is the Flemish ban on fireworks. But at the one hand, both these decisions should be dwarfed compared to the impact, for instance, of the ritual slaughter case. And on the other hand, if you take a closer look to the substantive arguments, you see that it's procedural and technical. In Belgium, the division of powers is very sensitive. So it's more because there was a violation of the division in powers and not because of real animal welfare argument. So in a nutshell, what can we learn now from this analysis? First, the positive attitude of the Constitutional Court. Although currently there is no Belgian constitutional provision, they did not stop the Constitutional Court to take animal welfare into account after all by referring to Article 13 TFEU. Secondly, if we go back to the original aim of the submitters, which was to provide a legal benchmark, we can conclude that it maybe is not necessary as the Constitutional Court created its own legal benchmark. And secondly, the positive attitude of the Constitutional Court should also be nuanced to some extent, as the judgments which were ruled were always brought to court by opponents who wanted less animal welfare and never by, for instance, an animal welfare organization striving for more animal welfare. So with this in mind, we proceed to the penultimate part of the presentation. So, new proposals. To restate briefly, we have the first option, purely symbolic one, Article 7 bis, a Belgium animal welfare state objective. Second option, a socio-economic right, added value is judicial review. But what is lacking, and that's the nature of a socio-economic right, is direct action by citizens. And therefore, the classic right can provide added value as it will allow for enforceability in view of subjective litigation. So by its nature, although it's inherent a negative obligation that the government must refrain from taking any action, it will allow for citizens to go to court. Then the fourth option, which is the introduction of animal rights. Of course, this is radically different from the other three. So the other three options examined above approach animals as legal objects with, although animal welfare is at the center, it's still about human rights, so a human being the direct beneficiary and animals being the indirect beneficiary. And always to activate such a right, a link is required with humans. With animal rights, on the other hand, animals are the legal subject. So their intrinsic value will count and no longer the value that they have for humans. And this option was also briefly touched upon in a discussion by the experts regarding the original proposal of Belgium animal welfare state objective. And one legal scholar pointed out that this option would indeed have major legal consequences, but that a downside is that it would undermine the credibility of the Belgian constitution, as it would constitute an enormous discrepancy between the reality, as in Belgium we have also industrialization of animals, and otherwise the norm. So it would undermine its credibility. But another legal scholar, on the other hand, pointed out to the positive function of such a discrepancy, as it can also be an unexpected incentive indeed for the Belgian government to align the reality with the norm. So although this option has a lot of potential, it was rejected as it would not be suitable in the current Belgian social context. However, in Switzerland, this idea was taken into account and devoted attention to, which culminated in the Basel-Stadt referendum in February 2022. And there the topic of the Basel-Stadt referendum was the right of non-human primates to life and to physical and mental integrity. Regrettably, only 25 citizens voted in favor of this proposal. Yet there might be hope. So if we again take the Belgium example, I pinpoint to a survey in 2017 when 42% of 3,000 participants agreed with the statement that the Belgian constitution should attribute animals the right to life. And if we take a closer look to the results, we see that even in the provinces of Liège and Luxembourg, this number increases to 50 and 53%. So with that in mind, we encourage the Belgian government to build on the Basel-Stadt referendum and even write history. So the concluding part, here a concise schematic overview of the four options. Also, should you be interested in the full results of this research, probably a journal article will be published soon in the Global Journal of Animal Law, which in fact also published the first part of this research regarding the German animal welfare state objective. So moving to the take-home message, what should you remember? So my name is Elien Verniers, and I've analyzed today with you the Belgian constitutional context for animal welfare and animal rights. And much will depend on how a right is formulated and where it will be positioned. But I argue that the Belgian government should dare to think out of the box and at least consider a classic animal welfare right and ideally aim for a fundamental animal rights. So thank you for your time, and don't hesitate should you have any questions.